And the the complainant got a small monetary settlement, and then the respondent essentially ghosted us. And that went on for a while, and I was kind of like, well, I mean, it's not that it was like, an egregious complaint, but a deal is a deal, and we had a deal. So we went to the Department of Law and asked for enforcement of the predetermination settlement. And ultimately, the Department of Law came back and said, you don't have authority to be entering into these agreements. And reasonable lawyers can disagree. And I definitely had, when I told some of the respondent counsel of cases that were in active predetermination settlement compliance, I was like, hey, look, I got to claw these back and finish the investigation because I'm not going to be able to enforce these. We haven't issued a closing order yet, so I got to pull them back. And I ended up with some fairly detailed emails back that were cited and said, of course you have inherent authority to do this, and here's all the reasons why, and here are some cases. And I said, well, I respectfully, the Department of Law disagrees with that, and they are my counsel, so this is what we got to go with. Um, for a couple of those cases, we ultimately agreed. I mean, the counsel was like, look, one of the main reasons that their clients wanted to do enter into these predetermination settlements was because of the cost savings for them and Ash for conducting the investigation. And they said, look, what if we voluntarily comply with this? We will finish these on our own if you're willing to still give us a closing order. And I was like, kind of reluctantly, I said, all right, we'll do that. But keep in mind, I don't have an enforcement mechanism on these things. So, in the event that you guys need an extension or something like that, I'm going to have to say no, and I'm going to claw them back, and we're going to finish the investigation. Now, those cases, the respondent was very cooperative and finished the compliance with the predetermination settlements, and they got the closing orders. But it forced Asher to step back and look at, all right, what are we doing with these resolution conferences? How can we still have the successes in keeping our overall timelines down without putting us into a situation of needing to enforce these predetermination settlements? Ultimately, it came back and was like, well, look, there is clear statutory authority for a complainant to withdraw the complaint. So, in a situation, and obviously the parties never, they don't have to, they can go off and negotiate on their own whenever they want to, whether they're in a predetermination settlement or whether they're in a resolution conference or not. Obviously, the parties can go settle. The concern that parties should always have is what are Asher's public policy concerns? Because I've got the ability to substitute in as the executive director to pursue those public policy goals. I mean, in the case where we smell some evidence that looks like it is going to be a substantial evidence case, and we're going to want the respondent to undergo training and do a policy change or adopt a policy. Yeah, I'm going to substitute in even where the parties have settled, and we're going to pursue those things. Now, you're not necessarily looking at, needing to pay the complainant at that point, because I certainly don't have authority to fine anybody. Um, but that was always a factor in the back of my head about like, well, what is going to be the incentive for the respondent to enter into, some kind of a settlement agreement if the specter of me substituting in is always going to be out there. And we're like, well, that's just something that we're going to have to accept and have to deal with. So we are still doing the resolution conferences. And it's still a very similar process to what it was. We're going to bring the parties in either in person if they're in Anchorage and available, or Zoom. I mean, for statewide, Zoom is fine. We're going to bring the parties in. We're going to see what facts we can get. We're still going to ask if the parties want to settle. But rather than having Asher or me be a component of that three-party settlement agreement, predetermination settlement agreement, we're pulling Asher out of it. We're pulling Asher's enforcement mechanism out of it. We're pulling anything related to Asher requiring training or a policy adoption out of it. So it effectively is just a two-party settlement agreement. And I'm relying kind of on the spidey senses of the investigators to come back and tell me, hey, look, this is a case that we should finish investigating. This really does look like there could be some public policy concerns, and I want to finish investigating it. Or, I've got my investigators will be like, look, from what I'm seeing right now, this doesn't look like it's a substantial evidence case. I'm not going to recommend you enter into or that you substitute in. We'll go ahead and let the parties settle. And we always make sure that as a component of their settlement, there is a withdrawal provision. And so that gives me the ability to close the case administratively on my end. Or if the investigator comes back and recommends that I substitute in, then I'll substitute in and we'll finish the investigation. Yeah, so I mean that's kind of what the change is. Now we're certainly not knocking them out of the park with these settlement agreements like we were, because there's always that specter of me substituting in. And I'm leaving it to the investigator conducting that resolution conference to either tip their hat to the parties or not as to whether they think that they're going to recommend that I substitute in or not. And that could certainly influence how those settlement negotiations go, and I recognize that. But I'm going to leave that in the hands of the discretion of my investigator handling that resolution conference. So that's kind of the big change, and that it has definitely meant that a lot more cases are going to investigation now. But even if cases are going to investigation, by using the resolution conference process, we've still shortened the case processing time, because we've still done the thing with narrowing the issues, determining who the witnesses are that we need to be looking at, figuring out what it is that the complainant and the respondent expect that these witnesses are going to say. And so we're still ahead of the curve as to where we were a couple of years ago, even if our case timelines are going up a little bit. But for that matter, our average, even with this change, when I was looking at it for the budget narrative that I've got to send to the governor's office to ultimately go to the legislature, we calculated our average open case right now is 290 days. We still have a few cases outstanding that are longer than a year, and they've got various reasons why those have been taking a little bit longer. One of them ended up being a voluntary remand when the complainant appealed to the Superior Court. We're like, all right, fine, we'll claw this back and interview a couple more of your witnesses. But I mean, and that was a case where we'd actually issued a determination. So that is kind of where things stand. I also admit that Greg Fisher had asked me to do this a couple months ago, and I had agreed to it. And then Greg said there was something going on with the Bar Association, and so we canceled this. So I was kind of surprised to see my name on the agenda last week. And so, yeah, I'm hoping you guys have questions. I'm not sure what other related issues we've got going on. That's kind of the big thing. Oh, I guess another related thing. One of the other longstanding complaints is that Asher doesn't have an agreement with AERC. And so sometimes a complainant will come and attack on both fronts. And so you guys end up having to defend on both fronts. We have now remedied that. There had been some historical reasons that there was a breakdown between Asher and AERC in I don't know, 20 plus years ago. But we've reinstituted a pseudo work sharing agreement, a memorandum of understanding with the Anchorage Equal Rights Commission to avoid people having to respondents having to defend on both fronts. So we're going to be able to do some information sharing and some adoption of each other's determinations in the same way that each agency already does with the US EEOC. So we are still working on the procedures. We hope to have that fully implemented at the beginning of the year. That's the only related thing I can really think of. So I'm hoping you guys have tons of questions. And I see that we've got a couple of assistant AGs, including our assistant AG for the agency online, and Helen is online here too. And I always appreciate Bill Milks's expertise in the agency's history too. Nobody's jumping with questions.
All right, I have a question. Can you hear me?
Yes, please.
Okay, so just I'm out of curiosity, what is sort of the average percentage of finding substantial evidence? Like in the last, I don't know, last 6 months, last year?
I mean, that really hasn't changed. I'd say we're probably still around 10% of SE determinations.
Okay. All right, yeah, I was just kind of curious about that.
Yeah, I mean, that hasn't changed. I mean, the evidentiary standard is what the evidentiary standard is that is set in statute. And I mean, the goal for the resolution conference procedure was to reduce the case processing timeline and make sure that even when we do issue NSE determinations, that we've got a record that we can defend on an appeal.
And also how many, like I say, I guess say in the last year, how many were appealed? Do you have a number on that?
I'd have to go look at our annual. I mean, we're going to be putting out an annual report here first at the beginning of the year, so we can look at that. But I don't know what those numbers are off the top of my head. I'd have to look at our last year's annual report to even tell you what they were from last year. We
Well,
haven't had we haven't had that many. I can only think of one. Although I would defer to Jocelyn since Jocelyn's our attorney and should know since she's the one defending them.
I'm sorry, what was the question again?
How many appeals have we had in the last year? I know you've only been around for a couple of months, but how many ASHA appeals are you working on right now?
Oh, right now I can only think of one, but I don't know the number right off the top of my head. Sorry.
and also I have another question. How many have you taken to hearing, like in the last year? I know that you're gonna have a report coming out soon, but I was just, maybe you have that information.
Taken to hearing, or we advanced an SE, failed conciliation.
That you actually, I guess you act, yeah, I guess you actually took to hearing. I guess assuming that, I guess it would fail conciliation and you had
So,
to take it to hearing.
okay, so I mean, I am a litigation attorney, right? I mean, I was a DA for 5.5 years. That was my, when I went to Reeves and Modio, they brought me on because of my trial skills. And I told you guys, hey, look, the rules of evidence make me warm and fuzzy inside. I don't even have to pick a jury. Let's go. And then I hired Helen. She's another DA. She's got more trial experience than I do. And the rules of evidence make her warm and fuzzy inside too. And so I wanted to change Asher's perception among the labor bar that we were afraid to go to trial and that, anything at Asher was either just going to get delayed forever and then, ultimately we weren't going to do anything with it. So, I mean, I still wanted to be that forward with you guys and with the complainant and with the respondents. That being said, we've had almost every single thing has ultimately settled in one way or another. I had one case that was my actual case. I was up against Phil Widener. It was a public accommodation service animal case out of Fairbanks. And I was like, why are we even here? So I ended up winning on a motion for summary judgment. And the only issue that we went to hearing on was on the remedy. And I'm like, it's a public accommodation case. There's not any money at stake here. Um, we just wanted the guy to adopt a policy and do training. Um, and it turned into this rigmarole about, well, the guy's about to go through a bankruptcy and he's facing all these health problems and blah, 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 blah. So we did a hearing on the damages, but I'm like, I didn't have any witnesses to put on. It was just, Phil put his client on the stand and the guy basically pled poverty and bankruptcy and health, and he was shutting his business down anyway. And so, it was a short hearing in front of Judge Kennedy, and the ultimate outcome was, all right, if you start a new business in the next 2 years, you have to adopt a policy and do training for you and your employee, which was his wife. So that's the only case that we actually like have done a hearing on in front of a judge. Everything else, when we filed the accusation and moved forward, um, has actually it has tended to settle, except for the stuff that we've got in front right now. We are in a bit of a litigation fight with the Department of Law on a prisoner religious discrimination claim. And so that is one that we are still moving forward on. We are in discovery, and there's definitely some motion practice taking place on that one.
If we could back up and if you're willing to entertain questions about a sort of the middle part of the process, you've mentioned the average duration of time that files are open and this resolution conference procedure. Could you speak to whether there are certain things which, after the parties sort of get past the resolution conference and your investigator is really digging in, that are helpful to making that process, I don't want to say speeding up that process, but making it go more smoothly? Like, are there things that your investigators see counsel doing that are, some counsel are doing that are more helpful that, we should know about to sort of do better on our end?
I mean, just being responsive to the investigator, getting the documents as fast as we can, that is always what is helpful. I mean, the investigators, as part of their evaluations, are also being evaluated more seriously, more heavily on how long any of their cases are, how long they've been open. So I mean, the faster you can get your clients to get you documents to get into our hands, the sooner the investigator is then going to look at it and develop that record.
Hi, Rob. This is Jennifer Alexander. Can you hear me?
Of course.
Oh, hi. So I have more of a comment than a question. Given that there's a bunch of practitioners on, I don't know how other people feel about this, but I thought I would weigh in. It's not a complaint. I actually really like the changes in the process. I think they've certainly made things move quicker and they help to get to the meat of the case. One issue that I've had come up a couple times is that I might have a multi-layered complaint where, an employee has a complaint about one thing and a complaint about another thing. And I know you guys are fairly strict about your rules about having only, one person be the fact witness during the conferences. And I appreciate not having two people at the same time so that you preserve that, that you're not having witness testimony sort of tainted or whatever. But like I said, I've had situations, and I've had this come up a couple times where I've had either been able to address one issue or the other with, I simply can't address both issues with one person. Like, there's just no way. And I think that one of the cases I had with that situation has since been resolved. The other one is ongoing, but I feel like that were we able to have that opportunity, I know you don't want fact-finding conferences to take 6 hours or turn them into mini trials, but I think there's situations where if you would have that opportunity to potentially have two witnesses testifying separately as the fact witnesses, that it might help advance the claim. And that's just my one comment. I think you've heard my pitch in writing on this before, but I just thought I would share it with the group.
That's a completely fair criticism of the process. I mean, my concern is that it could become overwhelming both to the investigator and the complainant. If there's like a room of 10 people in one side and one complainant in the other room, for at least for the part when they're all together. And then it's like how much, I mean, I don't want to turn them into mini trials, and I don't want to have them take 10 hours. I can't have an investigator sitting that long in getting that. Totally fair criticism. But I mean, even if you've got the one fact witness that we can get some testimony from immediately right there, and you know what the other fact witness is going to say, present that to the investigator. That'll still make it easier for the investigator to then frame their questions for when they go to interview that person.
Thank you.
This is Sarah again. I have one more question, sorry. I just out of curiosity too, how many investigators do you have currently?
Right now, I've got 6.
Okay,
We've Donna Nass is retiring. So if you've got any cases assigned to her right now, she is we're not going to be assigning any new cases to her. We're gonna keep her on to allow her to wrap up the cases she's currently assigned to. That'll also avoid then an assignment to a new investigator, and a new investigator has to go through the file and figure out what's going on. So even though Donna's caseload is going to be going way down as she wraps up her cases, the goal is to still keep those cases moving and those time frames tight, as opposed to the learning curve that a new investigator would get picking up a new file. So I am advertising for an investigator right now. Ideally, we would bring in an investigator at a 2 or a 3 level. Right now, we've got somebody at an investigator 1 who is assigned to intake essentially. And it just doesn't make sense for us operationally to have more than 1 investigator 1, because someone who is brand new to the agency is just learning how to do issue spotting and what the fact patterns are like, that kind of thing. So, I mean, if you know of anybody who already has some experience doing investigations, or maybe a paralegal who knows what's going on in terms of Title VII and AS 1880 claims, I mean, that's somebody we might be able to bring on at the 2 or even the 3 level. So I've got the position advertised. I'll see who's out there, but if I don't get anybody, I don't get anybody, and we'll just, in about 6 months, we think that the investigator 1 should be ready to move up to the 2 level, and then we can just hire somebody fresh as a 1. And I'm also hoping that by the end of this this next calendar year, maybe even at the end of this month, when we look at our numbers, we should hopefully, fingers crossed, have all of our cases as an absolute underneath 1 year. Anybody got anything else?
I'll ask a question. So,
Please.
everyone, Eva Gardner at the Muni. So, Rob, I remember your first appearance at this section, which I think was shortly after you took your job, and you were like, "Hello, I'm new here. I'm excited to learn more about this area of law." And I'm just wondering if you have any takeaways from the last few years. What has anything changed in your way of thinking, or have you, accomplished anything in particular that you set out to accomplish, or come to terms with anything that you thought you might want to change?
Yeah, I mean, a lot of things. I mean, the agency had been, in my opinion, stuck in a late 90s, early 90s office environment. My predecessor I guess 2 predecessors ago, Marty Buscaglia, had done quite a bit to just update the agency. I mean, when she got there, they were literally using 1 computer that had internet access, and everybody had to go share that computer if they wanted to use the internet. And this is into 2015. And so she did a lot just for basics. Like, she got a case management system, and I should also credit her deputy Sarah Monkton for implementing a lot of that too. But when I got there, I mean, the transition to a all digital office hadn't been completed yet. We still had a lot of paper files, and we were still using an analog PBX phone system from the 90s. So I mean, we just decided to completely bypass even using the Cisco phones and VoIP, and went directly to an all Zoom based office. So, I mean, in terms of efficiency, and especially having to implement teleworking, that made things actually a lot easier. So everybody's in the agency's got a cell phone and it has the Zoom app. And I mean, even a receptionist can be remote because the Zoom app is on the laptops and can do all of the transitioning that way. So some of that has been great. Implementing flex positions for the investigators. You know, when I got here, it was a project they had started to create a flex PCN so that you could bring someone in at a 1 who we don't expect to know anything and train them up, you know, to learn some investigation stuff and then finally be kind of the journeyman level at a 3. But they hadn't gotten the paperwork, the red tape done through the Division of Personnel to get that done. So I finished that. That definitely helped with our investigation timelines too, because it allowed us to then bring the trainee in just to do the intake. And allowed the implementation of the resolution conferences with the most experienced investigators who know how to do an interview, who know how to do the issue spotting, and take care of it kind of at that level. I mean, I got rid of the mediation program because I was like, well, we do this resolution conference thing. It kind of substitutes in for mediation. Honestly, not always a huge fan of mediation because I mean, you think about true mediation, you know, one side can browbeat the other side until they finally give in because that's like the middle, right? It's what they agreed on. But I like the idea of it being still informed by the facts. So that way the investigator still kind of knows what's going on as opposed to being a true neutral mediator. That being said, I was also looking at like, well, look, if a case hasn't settled by the time we're at accusation stage, OAH still offers judicial mediation. So there is still an opportunity for mediation, and that comes out of the ASHRA budget. We still pay for it through an RSA. So we're still kind of offering mediation, but now it's going to be done by the ALJ rather than at the beginning level. Freeing up that PCN allowed me to bring in a dedicated new attorney as an outreach coordinator. And that has also been fantastic. You know, as my special projects attorney, he's somebody that I've been able to assign specific things that I think you need to have the JD for. And even in terms of like going out and talking to businesses and stuff, I think having the license to practice gives that person some credibility when they're coming in and telling a business, this is why you screwed up, this is what you need to do. And so having Alex for the last couple of years has been fantastic. He's also gotten us kind of put together. Our outreach has gone through the roof. You know, we're doing outreach 4, 5, 6 times a month now in various ways, various capacities, because I've got someone kind of dedicated to that. But he's also someone that I'm like, I can hand a guidance document to and be like, hey, look, I want you to update this guidance document. We need to create a guidance document. I mean, like there've been some questions around ballot measure 1. And it's like, well, how does the speech implications impact a religious discrimination claim? And, you know, that there's obviously an intersection with the First Amendment there for businesses. And I'm like, all right, you know, Alex, go draft me up a guidance document. And so Jocelyn, we're drafting up a guidance document. We're going to be sending that to you for review here pretty soon too. But I've got somebody dedicated for that. One of the things when I got here, I was also like, it'd be nice to have a practitioner's guide. I mean, I was new to this area of practice of law. I mean, I had to figure it out. But I remember like Clint Campion got a case. And it was his first ASHRA case too. And I would have loved to have been able to hand him a law review article. And it's like, all right, Clint, here is the basics of all of our case precedent. Here are the important holdings that you need to know. Here are, you know, for the most part, we use the rules of civil procedure, but here are the couple weird tweaks that we've got. Here it is. And then I also want to just kind of write down the agency history. And as we celebrated our 60th anniversary last year, the agency history ended up taking on its own thing. And what I had assigned Alex to do is, you know, write a law review article has turned now into a, wow, this thing is huge. We probably need to publish this on our own, or maybe do the history as its own ASHRA publication. Maybe we'll still do the law review article as the practitioner's guide. So that he's done that. I mean, that's still on my plate to review and get out the door. But that was something that I really thought would be important and useful to you guys. something that I wanted to do that I got told basically no by both Westlaw and Lexis was to create a searchable Boolean database for Asher's cases. And it was kind of at the beginning of the pandemic when I was trying to fish around with Lexis and Westlaw. Westlaw basically ghosted me. Lexis came back and said, look, you don't have enough cases and we don't think there's enough demand to justify creating a database of just your cases. So I'm, that one I've kind of given up on. Maybe not entirely, but it's definitely, it got to the very bottom of the pile of things that I wanted to do.
Thanks.
One thing I am super excited about is in terms of our outreach, part of our outreach has been, I wanted to get kids interested in civil rights. Because it's like, what do you learn in high school when you're in your senior government class, or throughout school? You learn slavery was bad, then you had the Underground Railroad was good, and then Reconstruction was kind of okay, and then we ended up in Jim Crow, and Jim Crow was bad, and then Rosa Parks was good, and Martin Luther King Jr., and throw in Brown v. Board of Education and Title VII of the Civil Rights Act, and there's your curriculum for your civil rights education in high school, right? And I was like, well, I mean, how do we teach kids what civil rights is to them? What should it mean to them as like a graduating high school senior? Because it definitely goes beyond that. It's like, all right, you're going to go out, you're 18 now, you're about to turn 18, you're going to go get your first job. This is what civil rights means to you. This is what discrimination is. This is what it is unlawful. This is what a sexual harassment claim looks like. So I was trying to figure out a way to get like a curriculum going. In the context of that, one of my high school friends leads this like social studies teacher statewide group. And she said, look, if you just put some lesson plans online, we're always looking for lesson plans. So we'll grab those and run with it, modify it as we need to, but run with it. And with Keoki Kim over at AERC, he was also like really, really invested in getting into schools. Now, being in Anchorage, it's easier for him to just go hit every single school. I can't hit every single school in the state. So I like the idea of the lesson plan thing. In the context of that, I also just wanted to have handouts for kids when we're doing booth stuff, when we're at AFN, when we're at the state fair. And I'm trying to rip off as many ideas as I can from other agencies. And so the New York, I think it was New York City Civil Rights Commission has got this like coloring book handout thing. So I hired a graphic artist to create this like coloring book handout thing aimed at like, 6 to 10-ish year olds. And the next thing I was thinking, because I've got a 9-year-old and he's obsessed with graphic novels. And I was like, what if we did like a graphic novel that talked a little bit about Alaska's own civil rights heroes, and hand that out. So we combined with AERC our EEOC grant money that we get, which is only $3,500. But that was at least the start. And I basically was like, look, I will pay for the rest of the development costs. And AERC originally had agreed, okay, we'll pay for the printing costs because we've got access to the Muni printer. Now that has now fallen away, so I'm going to have to print the thing too. But we've now developed a graphic novel, and I want to do this as a series. So the first one is 3 chapters. It talks about William Paul and the history of a little bit about the history of the Alaska Native Brotherhood, but focuses on his voting rights case that he took with his mom and his uncle. That because prior to his lawsuit, Alaska Natives did not have the right to vote. And then we do a chapter on Elizabeth Peratrovich, of course. But we also then talk about Alberta Schenck, who was the teenager in Nome, who got kicked out of the Dream Theater for being Alaska Native. And then the 3rd chapter is on the segregated regiments of the Corps of Engineers that built basically the Alaska stretch, the worst stretch of the Alcan Highway. and the discrimination that those guys faced, and it ends with the court-martial proceedings that took place for those guys. We've also then developed, this was Keoki's idea, but we've run with it, a bunch of little trading cards that talk about more than, I mean, we've got like 20 of them, that talk about, all of Alaska's civil rights heroes too. And, maybe we'll expand those into some future graphic novel chapters, etc. So we've got the draft out, but sorry, my computer, I gotta pull the computer. We've got the draft of the graphic novel done. We're working on a few other changes, and I ended up having Elizabeth Pratrovich's granddaughter look over that chapter, and she provided some edits. I've now made contact with one of William Paul's descendants as well, so the Paul family is kind of looking over that chapter too. So we might have a few more tweaks in some of the text, and then we'll get that out. But we've started sharing it. We shared it at Elders and Youth Conference this year. We had printouts actually at a commemoration for the construction of the Alcan that took place last month. So I'm really excited to get that out. We've now also met with the Anchorage School District because they're doing these academy model changes, right? So they're doing a larger overhaul of what they're doing in schools. And they already they're excited. They were like, give us the file, we'll print your graphic novels because the teachers are going to eat this up. But we expect to be more involved with them as they develop their curriculum as well. And then ultimately, I still want to create some lesson plans to put online that teachers statewide would be able to pick up and incorporate in too. Sorry, thank you, Ava.
Yeah, no, that was very cool. Neat efforts. So another question. You have a lot of practitioners here, and it's been a while since I think you maybe talked to a room of employment practitioners. Are there any things that you'd like people to know, right? Are attorneys generally, when you have them in cases, helpful? Do they get in the way? Are they, pushing too hard for their clients, maybe in situations where the facts aren't there? Or do you feel that they bring clarity? And any tips you might have for our group would be helpful.
I would invite Helen to jump in on this too, but from the respondent standpoint, from most of you guys, I'd say it is helpful. When a client is unrepresented, when a respondent is unrepresented, they often just bury their head in the sand and like to pretend that this is just going to go away if they ignore us. And that then just puts us into sometimes a more difficult situation. And then we got to issue a subpoena, and then I got to go talk to the Department of Law about getting the subpoena enforced because they're continuing to ignore us. And so that is frustrating, and it adds delay. And then nobody gets any certainty out of anything. And it just, evidence gets stale. That's also never good for anybody in resolving a case. So I'd say for the most part, it is helpful. For complainants, honestly, sometimes it ends up getting in the way. Obviously, complainants have a right to be represented, but it can sometimes get in the way. I'm still very much of the opinion, though, that, hey, look, if you've got a great case, if you've got an egregious case, I'm still happy to have Asher do the investigation. You go file your Superior Court claim, or you go file your Title VII claim in federal court, and we will hand you our investigation file with a bow on it once you give us a subpoena, a discovery subpoena that you filed the complaint. We had a case recently that, well, I shouldn't say recently, it was a couple of years ago, but the case just settled. Mark Choate ended up ultimately taking the case, and they settled for, I think he said it was over $700,000. And it was a really egregious complaint. And I was glad that complainant was able to get that kind of monetary settlement. I mean, because I wouldn't have been able to do it at that level. I mean, right? I can only do compensatory damages. But this complainant was definitely entitled to some punitive damages and some contract damages, in my opinion.
Yeah, I concur with what Rob is saying. I find that having counsel really helps facilitate negotiations. And even on the complainant side, for the most part, I find it very helpful. It can become a little less helpful when the attorneys are difficult to get a hold of. But other than that, I find it incredibly helpful. I think you guys act as a great intermediary with respondents and with complainants, explaining, taking the time to really go through and vet the issues and bring forth both their concerns and their goals. So I find it very helpful. I really enjoy that. I think it's good. Very positive. And I learn a lot. I learn a lot from you guys because I get to see a whole other perspective on things, and that's very important. So yeah, that's my 2 cents.
Yeah, I mean, Helen's right. For the most part, you guys are helpful, even on the complainant side. But I mean, we're a small bar association. We all kind of know each other. We all kind of know who the attorneys are that are difficult to get a hold of and are not responsive. And those are the same people that we deal with at Asher too.
Does anyone else have questions for Rob? I'll ask one more just because I'm curious. So you've been in your job for several years now. You've seen a lot of cases, like all different types of cases. When you came in and started seeing, right, the kinds of things that come through Asher, were you surprised by, you know, how illegally employers are acting, or were you, and if people are acting, or were you pleasantly surprised that it was not as bad as perhaps you feared? Or what is your kind of gauge of the temperature of the cases that you've seen over time?
I mean, it's kind of what I expected. You know, discrimination ends up being really subtle. But a lot of times, you know, most of the time, 90% of the time, it ends up being that it wasn't discrimination. There was a non-discriminatory reason that was not pretextual for the adverse action. I guess maybe I was surprised by how many cases it really were no substantial evidence cases. But that, I mean, that is what my assessment is and was. In terms of, you know, egregious fact patterns, it ends up being the no substantial evidence cases that are the ones that are the egregious ones too. Yeah, it's like my favorite was a fact pattern that was resolving right when I got to the agency, and complainant had come and said it was race and sex-based discrimination. It involved a fish processing facility, and he was a minority within minorities that were the bulk of this facility. And he claimed that he was fired because he was a minority and his supervisor was of the majority minorities there. And the supervisor didn't like him, and the supervisor was also looking at him in the group shower. And during the investigation, we had found out that the complainant had hit a coworker over the head with a frozen salmon on the processing line and got charged with assault 4 and was arrested by the state troopers and flown out immediately. And that was why he was terminated. And it's like, yeah, that's a non-discriminatory reason that is not pretextual, guy. Those are the fact patterns that I'm still like, why are you even at Asher? Why are you here? That those are the ones that end up getting me more than the actual discrimination ones. And it's not, I mean, it's not that often that we get just direct evidence of discrimination. And when we do, it ends up usually being the small business owner who just doesn't know any better. And they think that, you know, well, we're an at-will state, so I can fire anybody for any reason. I mean, you know, we just had one conciliate where it was a religious discrimination claim over a beard, and it's the employer thought, I can just require men to not have beards, and it's like, well, you know, unless there's a direct threat or something like that, the answer is no. And you know, they just had their grooming standard, and this is what they thought they wanted all their male employees to do. But that was also one where it's like, all right, once the new small business owner understood the law, you know, they were cooperative and conciliated the case. And it was a great outcome for Asher. Wasn't a huge amount of back pay. The employee got a different job pretty readily. but they took it seriously and are fixing the problem. And that still feels good.
Any other final questions for Rob?
Wow, I'm still able to take up almost an hour. So
Yeah. Well,
it surprised
thank
me.
you. Yeah. Thank you so much for coming. It's always really good to hear directly from the agencies that do this important work. And I think we're all glad that you exist and you're over there doing the work. Thanks.
Absolutely. And we're always, I mean, I'm always open to feedback too. If there's things that Asher can be doing better, please tell me. I appreciate Jennifer. Jennifer's got a lot of cases with us, done a lot of cases with us. But you know, it's like, I got to balance kind of where we're at in terms of bringing in witnesses like that. But if there's other ideas you guys have, I mean, even in terms of changing our regs, I want to do a larger regs package just to kind of clean some stuff up. But that's also been on a little bit of a back burner while I've been dealing with other issues too. So I'm open to feedback. Please give it to me.
Yeah, we've got 6 minutes left if anyone wants to give feedback. If not, then we could wrap up a few minutes early and everyone can have a snack break before their next meeting. Okay, perhaps the feedback will be given privately.
Well, I just want to thank you guys for doing what you do, because you really do enable us to more efficiently and effectively address policy goals. And that's really important. So I just want to say thank you.
All right. Well, thank you all. With that, we can adjourn. And again, yeah, huge thanks to Asher for coming. Bye.